It's just the opposite. You're revisiting these theories and themes in the law. You're reviewing the evidence. You're actually telling them and arguing and explaining what they saw. The best part about closing is everyone else goes home. All those witnesses are gone. Everything that went on during the show, no matter whether it was days or weeks or months, they're all gone. It's you who get to stand up in front of the jury and say, well, that was the trial, and it went on for days and weeks and months, but let me explain to you what it all meant. Let me explain to you exactly what the testimony was, what you should do with it, what the exhibits mean, how it all fits together, and how you carry out your duty as a juror by going back in the room and filling out the form the right way. You're explaining to them everything about the case. So think about it in those terms. A closing is way, way different than an opening where you're simply previewing what's to come and using the Dukes of Hazzard's effect and just touching upon things. Instead, closing is everyone else clears out of the building and it's for you to tell them what just went on. All right? So think about it this, introducing versus revisiting, previewing versus reviewing, undersell what is to come, explain and argue what just happened. And I have to stress one word on the slide, and it is argue. If we have one comment for students that stand up and give a closing, right, it is, where was the argument part? You gave me the story again. You gave me the story in past tense. Now we all know that Bobby went into the store. Now we all know that Bobby put the item in his jacket. Right? It's not just a past tense story. Tell me what testimony and evidence means. Right? Organize it and tell me what it means. Argue to me. Think of what it means to have a reasonable inference. I can have a fact, which essentially, when we saw the person on the surveillance camera, they came out of the store and their eyes went back and forth. That's a fact. That's a fact that came from an exhibit. It might have even come from testimony. What does it mean? We get to closing, I tell you what it means. You saw his eyes. You saw his eyes when he came out of the store. Does a normal person leaving a store come out and look left and look right as if they've done something wrong? No. And why did he do it? Because he did do something wrong. Because he was stealing that thing. And he took it with the intent to steal. I'm going to construct an argument and it's just about eyes. And that's a reasonable inference from the fact that we have. And you know what? My opponent, think they're going to have a different version? Yeah, and if they're doing their closing right, they better argue too. There's plenty of people that step out from a store and look both ways. Hell, if they're about to cross the street, we're all taught to look both ways, right? I mean, you're going to have arguments for both sides of the same evidence, but that's what you have to do in closing. Grab hold of facts, make reasonable inferences, and argue, argue, argue. Let's talk about a couple of things that we're not doing. So we're not doing the canned speech, I covered that. We're not doing past tense versus the version of opening. This is the other one, right? You've seen this. We have Talking Head TV now. You have CNN crews outside of every major trial. Right? Unorganized, unedited trial recap. I see these closings all the time too. First we heard from this witness. I asked this, and A, and B, and C, and then they got up and they asked a bunch of other things, and this, and that, and that. And then we called the second witness. All right? And it's a recap. You're the news reporter on a windy day out in front of the courthouse telling me what happened inside. That's not argument. That's not organizing your stuff and thinking about your closing first and making sure the whole trial fit into it. That is just saying, we were all here, but let me give you a summary of what happened over the past couple days in order, right? That's unorganized, that's unedited. You're the one that's supposed to be focusing down on your stuff. And I have a rule that when it comes to trial advocacy, it's not a perfect rule, but it helps the way you should think about that. When you are organizing your case and you're trying to put together these arguments for closing that can help dictate what goes on for the rest of the time, right? One of the things you can do is think about my 90-10 rule. 90% of your time should be organized the way you want the case to come out. It should be organized the way you're thinking of the case. We get in these bad habits with mock trial problems and the way that problems come to us through trial advocacy that it has facts sprinkled on both sides all the time. Even if it's a criminal case where someone has to prove a case beyond a reasonable doubt, there's facts for every witness, there's exhibits for both sides, it's kind of this even keel version. And a lot of students make the mistake of getting into this well, this good fact I want you to pay attention to. It's really good for me, and I've embraced it, and I like it, and it's a good fact. Hold on to that. They also have a bad fact, and I'd like you to reject that and not hold on to that and not make that part of what carrying out your duties as a juror today. And then let's go back to another good fact, and you go back and forth, and you argue for yours and against theirs. You know what? Edit. You compile all the stuff that you want to argue in the order you want to argue it. You assemble your 90% of the case by all the stuff that came out. You don't have to pay attention to every single bad fact that comes out. You have to organize why you win the case. And you know what? After you've organized that 90% of why you win the case, if they've done their job, there should be some stuff that flies in the face of it, right? But you've already spoken in an organized, assembled way about why your theory wins out, why your theme resonates, and why your story is the one that makes sense. So when that little crosses over, we heard from the defendant in this case. I've told you this organized 90% story about essentially a case of shoplifting that is, I think, an easy one for you, and I think you should go back in the jury deliberation room, mark guilty, and we can all move on with our lives, right? But we did hear from the defendant. And the defendant's version kind of crosses hairs with mine in a little way. I'm going to take my 10% of time, I'm going to take my 10% of my closing, and I'm going to address that. And I'm going to address it in certain ways. I'm either going to say, well, we know why the defendant testified that way. He had a bias to lie to us. Or he has credibility issues that are elsewhere. I'm going to say you reject everything he says for some credibility reason. Or I'm going to say even his version, where he says that he just picked it up but he intended to return it next Thursday when it was on sale, even his version, I'll take that. Because you know what he said in that version? He said that he took it. And that's all that matters, and that's all you need to find to get this element. So I'm going to take those things that cross hairs with my case and I'm going to address them head on, but I'm going to do it only after I've set forth my entire case in a 90-10 way. So focus on your case, focus on your theory, focus on why you win and how you're going to explain that in a clear theme to your jurors. And then, lesser portion, some lesser portion, 10%, address the other side, react to the other side. And you'll see when I get to the parts of closing that I want you to do that.